The Subcommittee on Health and Employment, Labor, and Pensions will come to order. Welcome, everyone. I note that a quorum is present. The subcommittee is meeting today to hear testimony on closing the courthouse doors, the injustice of forced arbitration agreements. This is an entirely remote hearing, and as such, the committee hearing room is officially closed. All microphones will be kept muted. As a general rule to avoid unnecessary background noise. Members and witnesses will be responsible for unmuting themselves when they are recognized to speak or when they wish to seek recognition. If a member or witness experiences technical difficulties during the hearing, please stay connected on the platform, make sure you are muted, and use your phone to immediately call the committee's IT director, whose number was provided in advance. Should the chair experience technical difficulty or need to step away, another majority member is hereby authorized to assume the gavel in the chair's absence. In order to ensure that the committee's 5-minute rule is adhered to, staff will be keeping track of time using the committee's digital timer, which appears in its own thumbnail picture. Members and witnesses are asked to wrap up promptly when their time has expired, please. Pursuant to Rule 8C, opening statements are limited to the chair and ranking member. I'll now recognize myself for the purpose of making my opening statement. Today we meet to discuss employers' use of forced arbitration agreements and collective action waivers and how these arrangements affect workers' ability to secure fair treatment. On their first day of work, employees flip through a stack of papers, click a series of modules, and sign the terms and conditions of their contract. Even before their first day, employees often skim through a dense job application. More often than not, these documents include an arbitration clause. Hidden in the fine print, which states that an employee cannot take the employer to court. Instead, the employees must bring their claims to a closed-door meeting with an arbiter who may not even have a law degree, and the employee will have no right to appeal the result. Workers who carefully review these agreements are forced to choose between signing or walk away from their job. But most of the time, employees sign these clauses and do not realize until they have experienced workplace violations and seek justice. Unfortunately, over the last 3 decades, some employers have increasingly used forced arbitration clauses to circumvent workers' right to due process. In 1990, 2.1% of non-union employees had an arbitration clause in their employment contract, 2.1% in 1990. As of 2018, nearly 60% of all non-unionized private sector employees were covered by forced arbitration agreements. Once again, in 1990, 2.1, in 2018, 18 years later, 60%. That's 60 million American workers locked out of a courtroom and forced to go through a process that often is rigged against them. While proponents of forced arbitration describe it as a more efficient litigating in court than court, we will hear from our witnesses today on how it is not efficient and oftentimes less efficient than normal litigation. When workers do enter into the arbitration process, they rarely emerge victorious. Research shows that employees have an overall win rate of around 19%. And when an arbiter is paired repeatedly with the same employer, that win rate reduces to nearly 11%. In contrast, employees are more than 30% likely to win when they go to federal court. As a result, arbitration has become a tool of some employers to evade accountability for violating their workers' rights. In the 10 most populous states, workers have $8 billion stolen from them in minimum wage violations every year. This amounts to $3,300 in losses per worker every year. The federal minimum wage is inadequate as it is, and without protections, workers are left with even less, while the employers line their pockets, and duck litigation. Forced arbitration also makes it difficult for workers to seek justice when they experience discrimination. Arbitrations are private and allowing employers to be shielded from the court of public opinion. Additionally, the ordinary rules of discovery and evidence common to the courtroom rarely apply, so employers can control the evidence that is brought into the room. These unfair practices allow employers to hide abuse while stacking the cards against workers who experience discrimination. In recent years, the Supreme Court has only worsened the problem. In 2018, the court's conservative majority ruled in the Epic Systems Corp versus Lewis case that an employer can even require employees to give up their right to join a joint class or collective action. This leaves employees to try their case as individuals and prevents them from proving that their experience is one of many. Ultimately, this prevents employers from being held accountable. But as Justice Ginsburg wrote in her dissent, quote, congressional correction of the FAA over workers' rights to act in concert is urgently in order. That's why today's hearing will focus on the Restoring Justice for Workers Act introduced by Chairs Nadler and Scott. First, the legislation reopens the courthouse doors for workers by prohibiting the use of forced arbitration clauses in employment contracts prior to dispute. Second, it reverses the Supreme Court's decision in Epic to ensure workers can band together to hold unscrupulous employers accountable. And finally, it ensures that after an employment dispute arises, employers cannot obtain arbitration agreements by threat or coercion. I'd like to congratulate my colleagues on the Judiciary Committee for their efforts to advance the Forced Arbitration and Justice Repeal Act, or the FAIR Act, which ends forced arbitration employment in many other contexts. This legislation is crucial for employer workers' rights under the statutes this committee oversees. The Restoring Justice for Workers Act builds on the FAIR Act by including essential provisions like making collective action waivers on unfair labor practices under the National Labor Relations Act and preventing forced post-dispute arbitration. If workers are shut out of the court system, they are not protected under the law. This is an outcome we should not accept. We cannot accept. I want to thank our witnesses for joining us today. I now yield to the distinguished ranking member, Mr. Allen, for purposes of him making his opening statements. Mr. Allen.
Thank you and good morning, Mr. Chairman. Before coming to Congress, I spent 40 years building a business, creating hundreds of jobs for Georgians. From a business standpoint, I can say without a doubt that H.R. 4841, or the so-called Restoring Justice for Workers Act, will be devastating for both employers and employees. This is just another instance of heavy-handed government reaching way too far. One thing our economy doesn't need right now is more burdensome regulations. But that's exactly what H.R. 4841 is. It's a burden. By banning arbitration in workplace matters, this law unfairly targets job creators and American workers. Arbitration is known as an effective and proven method for resolving workplace disputes, and the American worker demands choice. Arbitration provides practical and affordable legal recourse for employees who believe their rights have been violated. It also provides the necessary flexibility to address workplace claims of all sizes. Banning the use of arbitration unfairly penalizes individual employees and employers. This bill would hurt workers by delaying justice and resolution to disputes. Instead of trying to tie the hands of workers and employers, Democrats should be focused on getting our economy back on track and combating the rising prices caused by inflation and out of control spending. The only thing H.R. 4841 is good for is enriching our trial lawyers. The legislation will result in a tsunami of class action lawsuits, leaving many workers' claims unaddressed due to the costly and time-consuming nature of litigation. Outlawing arbitration and facilitating class action lawsuits will funnel more money directly from the pockets of workers and job creators into the wallets of trial lawyers. In most cases, arbitration is significantly less expensive and speedier than drawn-out court battles. Democrats claim that arbitration gives employers an advantage over employees, but in reality, costly court battles only benefit trial lawyers. It is unfair to force workers into judicial proceedings they may not be able to afford. This will be another case of Democrat legislation that will have unintended consequences of hurting those it intended to help by imposing a top-down big government solution. Our judicial system is already stretched thin, and the COVID-19 pandemic has already made things worse. Forcing all workplace disputes into the courtroom won't just exacerbate this backlog, it will clog our judicial system completely. Democrats must be aware that this is bad legislation. Why else would they exempt the unions? H.R. 4841 bans all arbitration except when it comes to arbitration clauses in collective bargaining agreements. Exempting big labor from this bill tells us everything we need to know about how much it will disadvantage job creators. Democrats also have a bad habit of trying to treat all Americans the same, but our workers and businesses do not fit into a one-size-fits-all box. The American workforce is diverse. It does not make sense to treat independent contractors the same as salaried or hourly employees. Independent contractors set their own hours and earnings and are entrepreneurs in their own right. Yet this legislation unfairly targets independent contractors and will ultimately decrease and disincentivize these growing opportunities. Everyone here wants to see our workers thrive. We also want to see those who have been mistreated receive justice. The real question at hand is, what is the most effective and efficient way to get justice for both workers and employers? I believe outlawing arbitration, as H.R. 4841 would do, and shoving every workplace dispute into an overwhelmed court system will delay the very justice that mistreated workers need. The last thing this economy needs is more control and regulations from Washington. Forced lockdowns, a supply chain crisis, rising prices and inflation, and the worker shortage are already wrecking our economy. Legislation like this could be the nail in the coffin for many struggling job creators. In the end, those who will suffer the most from H.R. 4841 are the workers who won't be able to have their cases heard, and the employers who will be forced to tread water continuously under the heavy weight of endless litigation. And with that, Mr. Chairman, I yield back.
Thank you, Mr. Allen. Without objection, all other members who wish to insert written statements into the record may do so, submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on November 18th, 2021. Now I'd like to go to our witnesses. Thank you all for participating today. We look forward to all of your testimony. I'd like to now introduce the witnesses. Professor Alexander Colvin is the Kenneth F. Kahn Dean of the Cornell University School of Industrial Labor Relations. Ms. Glenda Perez is a former implementation setup representative at Cigna. Mr. Roger King is a senior labor and employment counsel at the HR Policy Association. And Ms. Kalpana Kotagala is a partner in the law firm of Cohen, Milstein, Sellers, and Toll. I apologize for the mispronunciation. As you can imagine with my name, I'm used to people doing the same thing to my name, so I apologize. Unfortunately, it hasn't made me better at pronunciations. We appreciate the witnesses for participating today and look forward to your testimony. Your written statement will appear in full in the hearing record, and you are asked to limit your oral presentation to 5 minutes. Your written statement will appear in full in the hearing record, and you are asked to limit your oral presentation to 5-minute summary. After your presentation, we will move to member questions. The witnesses are aware of their responsibility to provide accurate information to the subcommittee, and therefore we will proceed right now with their testimony. I will first recognize Professor Colvin. Go ahead.
Thank you. Thank you, Chairman Desaulniers, Ranking Member Allen, and distinguished members of the subcommittee. It's a pleasure to have the opportunity to testify today about the impact of forced arbitration on American workers. My name is Alexander Colvin. I am the Kenneth Kahn Dean and Martin Scheinman Professor of Conflict Resolution at Cornell University. Most workers discover that they have entered into forced arbitration after the fact. They are fired from their job and thought their rights had been violated, so they went to see a lawyer. After asking some questions and reviewing documents, the lawyer explained that way back when they were hired, amidst the stack of paperwork we all sign at the start of a job, was a document stating that the worker agreed to resolve any future employment law claims against the employer through arbitration. Now, the worker might believe that a private arbitration forum established by a contract drafted by the employer could not govern claims under statute enacted by Congress or a state legislature, that they retained their right to their day in court. The worker might object that he or she was essentially forced into agreeing because the employer stated that the arbitration clause was a term and condition of employment. No signature, no job. But the Supreme Court has held that an arbitration clause imposed as a term and condition of employment is enforceable. That's the essence of forced arbitration. The worker is required to agree to arbitration as a condition of getting or keeping a job. This forced arbitration clause can cover the vast majority of rights the worker might have, from protections against racial discrimination, sexual harassment, to rights of returning veterans, to rights to be paid a minimum wage and overtime. The arbitration clause is drafted by the employer, who is effectively deciding who is administering arbitration and what the rules and procedures will be. An example of the rules that many employers include in forced arbitration is privacy provisions that prevent the worker from disclosing what happened in arbitration. The result is that employees and public regulators may be unaware of systematic problems of discrimination or sexual harassment at a company because individual cases are kept under a veil of confidentiality in the private form of arbitration. Under the recent Epic Systems precedent of the Supreme Court, the rules of forced arbitration can also include a ban on bringing a class action or a collective claim. The worker is unable to pursue a class action in court because of the forced arbitration clause and unable to pursue a class action arbitration because the rules drafted by the employer do not allow it. Essentially, a heads I win, tails you lose situation. The inability to bring a class or collective action leaves many with low value claims with no effective recourse at all. What do we know about how this system of forced arbitration is operating? My own empirical research and that of other scholars in the area has yielded the following conclusions. First, forced arbitration has become a widespread practice. In my 2018 survey, I found that over half of all establishments in the survey were imposing forced arbitration on their employees. That's 60 million American workers subject to it. Second, employees do worse in forced arbitration than in litigation, winning fewer cases and recovering less damages. My research found that taking into account the chance of winning and likely damages, the average recovery per case for employees in forced arbitration was only $25,000 compared to $143,000 in federal court and $328,000 in state court. Similarly, a new 2021 study by Mark Goff of Penn State University finds that employees receive 203% greater damages in federal court and 165% greater damages in state court than in forced arbitration. And that's controlling for differences in plaintiff and case characteristics, comparing apples to apples. Third, employees are at a structural disadvantage in forced arbitration procedures. There's evidence of a repeat player advantage to corporations that have multiple cases before the same arbitrator, where these employers tend to win more often and have lower damages awarded against them. Fourth, forced arbitration reduces access to justice. As a result of the less favorable outcomes for employees in forced arbitration, there's a reduced ability of plaintiff attorneys to accept cases on the normal contingency fee basis, leading to far fewer cases being filed. Research by Cynthia Esland of NYU finds that cases are being brought in forced arbitration at only 1% to 2% the rate they're brought in court. If cases are not being brought, this means that our employment laws are going unenforced for much of the workforce that is subject to forced arbitration. How can the problems be addressed? The provisions of HR 4841, the Restoring Justice for Workers Act, would directly address the more pernicious effects that we're seeing in forced arbitration through ensuring that no pre-dispute agreements are valid or enforceable and restoring the ability to bring class actions and collective claims. It also appropriately preserves the beneficial use of arbitration in the collective bargaining and voluntary post-dispute context where it has been successfully used for many years. By contrast, the current system of forced arbitration imposed on workers by corporations undermines employment rights and should be eliminated. Thank you for your time.
Thank you, Professor. Thank you for being on time. I'd now like to recognize Ms. Perez. Your 5 minutes are available.
Thank you, Chairman. Chairman DeSaulnier, Ranking Member Allen, and members of the committee, thank you for the opportunity to testify in support of important legislation that would end forced arbitration for workers across America. My husband and I used to work for Cigna, a global healthcare insurance company, from October 2013 to July of 2017. I was an implementation setup representative structuring both national and commercial pharmacy benefits. I trained new hires and quickly became a subject matter expert. I won the Cigna Champion Award 2 years in a row. Through Cigna, I volunteered for the Red Cross and Habitat for Humanity, and I was featured on Cigna's Twitter page. To say I was proud is an understatement. I was honored to say I worked for the company. In March of 2017, meetings were held with my team to address an ongoing issue related to pharmacy benefits. The following month, my manager singled me out as being responsible for making errors and called me a risk to the team. My manager put me, apparently with other employees, on a performance corrective action plan. I was shocked and confused as I was sure that I had not made any such errors. When I asked to see the evidence of the errors, my manager refused. I asked my husband, who also worked at Cigna, if he could find the report with the alleged errors. He found reports of other individuals, specifically white women, who were making those errors. However, they were not participating in the performance corrective plan. I filed a complaint with HR regarding my manager's discrimination against me. Normally, a full investigation takes around 60 days. My investigation took 1 day, and HR simply agreed with my manager. My manager then put me on a far more oppressive performance plan. 2 months after reporting my manager to HR for discrimination, I was fired. When I wanted to file a complaint for racial discrimination and retaliation, HR said it must be handled in arbitration. I didn't really understand what arbitration meant. Apparently, I had e-signed an arbitration document in my onboarding employee packet. I quickly learned that forced arbitration wasn't an informal internal process, but instead a complicated, formal, and binding process that was nothing like mediation or going to court. I couldn't find any attorney willing to represent me in forced arbitration. I don't have any legal background whatsoever, so I tried to do my own research. We couldn't afford internet at home, so I used the Wi-Fi of a local dentist in the parking lot and struggled to pay for gas to drive to the law library. This was all while I was caring for my 3 children and looking for a new job. I filed a complaint in forced arbitration for claims of racial discrimination and retaliation. Cigna chose the arbitration provider, and it took several months just to choose an arbitrator. I tried to get information from Cigna to prove my case, including my employee personnel profile. Cigna's attorneys said that that discovery request would cost over $1 million, and the arbitrator denied my request. Cigna filed a motion for summary judgment, and a couple of days later, the arbitrator ruled in Cigna's favor and canceled the hearing. I was devastated, as I wanted to tell my side of the story at the hearing. That night, my husband found a photo on the internet of the arbitrator and the attorney for Cigna looking very friendly, hugging each other at the arbitrator's 50th birthday party. The arbitrator also used to work for the firm representing Cigna and even listed Cigna's attorney as a reference on his CV. To me, this obviously showed that the arbitrator was not impartial. Had I known of this personal relationship, I would have moved to disqualify him, but it was never disclosed. I filed the motion to vacate the arbitrator's award in court with the help of my husband, who hired a process server to deliver Cigna my motion. After Cigna was served, they fired my husband. It turned into a 4-year battle with no real opportunity to have my voice heard. A person should be able to hold the corporation accountable when they violate the law. Now I know that's not the case because of forced arbitration. Forced arbitration left us barely surviving. Little by little, the things we worked so hard for were taken from us. Our newly bought house is in foreclosure, our car was repossessed, we had to empty our 401ks and sell all my jewelry, including my wedding ring. We were on food stamps and relied on family members to help pay our bills and for things our kids needed. Not only were my kids robbed of their parents for 4 years, but I was robbed of my dignity. I'm in this fight to end forced arbitration because no one should have to go through what I went through. Workers should be able to protect their rights and have access to our civil justice system. I urge the members of this committee to support and for Congress to pass the Restoring Justice for Workers Act and the Forced Arbitration and Justice Repeal Act, a bill that I have long advocated for, which would end forced arbitration for workers and consumers. Thank you, and I look forward to your questions.
Thank you, Ms. Perez. We'll now go to Mr. King. Mr. King, the floor is yours.
Thank you, Mr. Chairman, Ranking Member Allen, and distinguished members of the subcommittee. I've spent about 50 years of my professional life working in the arbitration area. I've drafted arbitration agreements. I have represented clients in arbitration proceedings. I've been deeply involved in policy discussions regarding the merits of arbitration. I also have followed closely the FAIR Act, Mr. Chairman, that you referenced earlier, and I had the opportunity to testify before the House Judiciary Committee earlier this year regarding the FAIR Act, and a copy of my testimony to that committee is included in my statement this morning. I've also been involved in class action and collective action matters. So my testimony today represents that substantial professional and personal experience. This legislation that we're considering today, HR 4841, has two primary objectives. The first is to completely eliminate pre-dispute arbitration. I submit to you that is a serious mistake. Pre-dispute arbitration has worked well. And indeed, the approach this legislation is taking would prohibit Professor Colvin and I perhaps just to sit down and work out a pre-dispute arbitration procedure that we could agree upon. So nothing is available for pre-dispute arbitration. Second, the total prohibition on class action waivers is a substantial overreach. And of course, really the proof is in the pudding here, as Ranking Member Allen stated, because labor unions and employers are permitted to continue such arrangements. That in and of itself shows a major deficiency in this legislation. Let me move through a few points that I have in my testimony. But before I do that, I think we have a really substantial misunderstanding here. Virtually everything that goes on in an arbitration proceeding, at least the vast majority of cases, are what I would call standard workplace issues. Did I get the raise that I was entitled to? Was I properly disciplined? Did I get the vacation when I should have gotten it? Those are the kinds of day-to-day matters that are addressed in pre-dispute arbitration. They're not complex. They don't require expert witness. They don't require class action litigation. Those are what work. Those procedures are what work-related matters address. So you're going way overboard in this whole discussion. You're making everything into a very complex matter. But to the extent statutory rights are involved in any of these disputes, they are preserved. It's improper to say, as some of the testimony being submitted today, that statutory rights are being eliminated. That's a misstatement of the law. This legislation overrules virtually, or attempts to overrule virtually decades of Supreme Court case law. And these are not just 5-4 decisions. Justices Kennedy, White, Kagan, etc. were in the majority in these cases. They can't all be wrong. And it's a misstatement to say that the Federal Arbitration Act only is applicable to disputes between merchants. That is just a simple misstatement. Now, the proposed legislation essentially would do away with any incentive for employers, employees, and indeed even unions to a certain extent to work out pre-dispute arbitration procedures. The whole flow of our jurisprudence is going to a different approach. We're trying to resolve disputes through alternative dispute resolution. That's the way this process should work. With respect to union matters and the carve-out, there's some really misstatements here also, or misunderstandings. An employee in a union environment doesn't get to decide whether the matter goes to arbitration. The union makes that decision. The employee doesn't decide who its counsel is. The employee doesn't decide who the arbitrator is. And in fact, virtually every arbitration proceeding between employers and employees is subject to the American arbitration rules. So these are not complex negotiated agreements, etc. They're standard of the mill agreements. With respect to our court system, as Ranking Member Allen said, our court system is simply overflowing today with issues that have been waiting, and sometimes years, for disposition. To suggest that cases are being resolved in 8 months, as one of the witnesses suggests, is simply a misstatement of fact. Finally, with respect to comparing apples and oranges, and all due respect, Professor, your stats are right, but the comparisons are incorrect. You're comparing jury trials with standard run-of-the-mill arbitration settlements in most cases, or awards. Those awards are much different in a jury trial than they are in a standard I got disciplined incorrectly type of arbitration. You can't compare that. That's not just apples and oranges, that's apples and zebras. One of the most recent studies that's being articulated in the press and apparently being used to support this legislation by the Trial Lawyers Association counts settlements as losses for the employee. That's a misleading and inappropriate way to proceed. So the stats in this area actually show just the opposite. When you compare actual apples to apples cases, the claimants in arbitration do much better. This arbitrable system also has very distinguished and ethical people. I really think it's a misstatement to characterize arbitrators as having substantial conflicts of interest or somehow always siding with the corporation. The arbitrators I'm aware of over my 50 years of practice are very ethical and they try to do the right thing. And
Mr. King, if you could wrap up, please.
Yes, certainly, Mr. Chairman. They try to do the right thing and they don't play favorites. They have enough business and they do the right thing. Thank you very much.
Thank you, I appreciate it. Now we'll go to our last witness, Ms. Courthouse. How was that?
That was good, thank you.
I'm a slow
Thank you.
learner, but I'm not very bright.
No, it's a hard name. I appreciate the effort. It's Kalpana Kodagal. And my family's from India, so that's where the name comes from. Chairman DeSaulnier, Ranking Member Allen, and distinguished members of the subcommittee, thank you for inviting me today. At the outset, I want to just say that I and my colleagues at Cohen-Milstein have cases currently pending in arbitration, and I won't be talking about those cases today. I am eager, however, to offer what I have learned from litigating employment cases in forced arbitration for more than a decade. If you take nothing else away from my remarks today, please hear this. In my experience, forced arbitration in the employment setting poses such a threat to workers' ability to vindicate their rights and to our system of common law that congressional action is required. The justification for forced arbitration is predicated on myths, on fictions about how arbitration is a good thing for workers, and we've heard many of those today. I want to address a few of them. Myth number one, forced arbitration reflects actual consent and is a negotiation between similarly positioned parties. This is not true. On the one side are well-resourced corporations, on the other are individual workers who must commit to arbitration before a dispute has arisen. Pre-dispute, workers often can't appreciate that eventual claims will be decided in confidential and individualized forums with restricted discovery and limited appellate review before a decision maker often selected by the employer. There are places that binding arbitration in the employment setting may make sense. Where it is the product of negotiation between parties of equal bargaining power, and that's where this piece about unions and employers, where the union wields the authority of the collective of workers as well as substantial experience. That's not the case in most forced arbitration, as Ms. Perez's story tells us. Moreover, in my experience, forced arbitration burdens those who are already marginalized: hourly workers, women, Black workers, and workers of color. Myth number two, forced arbitration is speedy. Consider one of my ongoing cases, a sexual harassment case filed in 2008. It has already gone through 4 appeals of the arbitrator's decisions, and we still haven't made it to trial. This is because many arbitration rules permit appeals as a matter of right where there would be no such option in court. In our case, the appeals included challenging the arbitrator's interpretation of the arbitration agreement to permit my clients to even seek class certification, a step that doesn't exist in court at all. These years-long appeals are ironic. Arbitration was heralded as an opportunity to free up the courts, but evidence suggests that courts are increasingly dealing with litigation about arbitration. Finally, myth number 3. Forced arbitration does not impede the effective vindication of rights. The truth is that forced arbitration does just the opposite by deterring workers from filing claims to vindicate the rights granted to them by Congress. Forced arbitration provisions often include joint action bans, or as employers like to call them, class action waivers, which prevent workers from being able to proceed together, even when their claims challenge identical workplace misconduct. In my experience, the ability to conduct discovery and distribute costs to advance the shared claims of many workers at once makes those cases possible. Barring class and collective actions makes it nearly impossible for workers with smaller claims. And while mandatory arbitration in employment with adequate guardrails post-dispute may sometimes make sense, I cannot, as I sit here, envision a situation where bans on joint action ever do. Employers' own statements confirm that their primary concern is preventing workers from joining together. Indeed, some companies have announced their decision to end forced arbitration only for individual sexual harassment matters, acknowledging that it impedes accountability. If ending forced arbitration is the right thing to do, as one company put it, for individual sexual harassment claims, why are systemic discrimination claims any different? Joint action bans also cause inefficiency and inconsistent outcomes. Whereas class and collective actions can only proceed where a court agrees that the claims can be fairly and efficiently adjudicated together and that class counsel is experienced, joint action bans apply categorically, requiring serial litigation of the exact same issue. Claims that might have been adjudicated together in a single action are instead decided many times over, risking inconsistent outcomes. Finally, forced arbitration undermines our system of common law, by which judges author opinions that are subject to scrutiny. Forced arbitration is typically confidential. Matters of public consequence are hidden from sight. I was heartened to see in Mr. King's testimony that he agrees the secrecy in which forced arbitration is shrouded is alarming and should be prohibited. Moreover, arbitral decisions are not precedential. There is no notion that today's decisions must flow from yesterday's. The Supreme Court has described forced arbitration as nothing more than a change of forum. In reality, moving employment claims from the courthouse to a conference room fundamentally changes the playing field, creating a system of secret decisions that lack protections and undermine the integrity of our legal system and the atrophy of common law. With that, I thank you and I welcome your questions.
Thank you all the witnesses for your testimony. Under Committee Rule 9A, we will now question the witnesses under the 5-minute rule. I'll be recognizing subcommittee members in seniority order. As chair, I now recognize myself for 5 minutes. Professor Colvin, you discussed research by Cynthia Ethlin on how workers bring cases to forced arbitration at only 1 or 2%. Many Americans don't look at the judicial system as being as fair as we would like it to be. So some might use the word rigged. Can you talk a little bit about your research? And if you'd like to respond to Mr. King's comments about your research, feel free to use some time for that as well.
Sure. So I think one of the critical issues here is, do we have a forum that allows workers effectively to bring claims? Cynthia Eslin's research, which builds on some of my own work, has found that we really don't see very many cases at all being brought in arbitration relative to the large number of workers being covered by forced arbitration. Now, what's going on there? I think really the crucial thing is that the outcomes are so much less in our forced arbitration. The damage awards, the win rates are lower, that it's really hard to bring a case. One thing that we know from the research is that it's really hard to do it by yourself. Ms. Perez's testimony, I think, is very reflective of what we see in the research. It's a huge hill to climb to do it by yourself. You need a lawyer. But in practical terms, the lawyers can't bring the cases when the outcomes of the chances of success are really low. And that's really the big barrier we're seeing, why we don't see very many cases. The research we've been trying to pull this out in terms of controlling for all the different factors that may be going in here, but we're really consistently seeing this large barrier to bringing the cases.
Thanks. Ms. Perez, maybe you could speak to your experience. You mentioned about how difficult it was just to get the resources you needed and an attorney given your own budget. maybe you could speak to that a little bit.
Yeah, I have no legal background whatsoever. So entering into arbitration, I didn't know what I was going into. The company has all the rules because they're the ones that hire the provider, so they know what to expect. When I entered into the arbitration, I was told in the beginning that it would be informal. However, it quickly became formal. So I had to quickly learn the federal rules of civil procedure. Again, I have no legal background. So having to learn and get my own discovery, it was just a tug and pull, and many trips to the law library using their computers. It was extremely difficult because not only did I have to learn this, but I also had to write the motions. So it was extremely difficult.
Thank you. Ms. Codigal, maybe you can talk a little bit about just the difficulty that employees have with discovery. Ms. Perez talked a little bit about this.
Yeah, absolutely. Thank you. So the thing about proceeding along discovery in arbitration is that the rules, the federal rules of civil procedure, the federal rules of evidence, the tools that we use to shape the discovery that we ask for are sometimes not present. And then the second piece of it that I think is really important is that where you are forced to proceed on an individual basis, you have access to less discovery. The rules of so-called proportionality in discovery mean that even if Ms. Perez were the victim of a pattern of discrimination at the company, she wouldn't have access to evidence showing that. And so those limits on what you can get as an individual trying to understand where your situation fits into the company's policies are tremendously significant.
Thanks. Professor Colvin, short time I have left. I'm from the San Francisco Bay Area. Like Mr. Allen, I was an employer. I owned restaurants. I didn't have these issues. Best not to have conflict with your employees, but I understand how to make a payroll and manage people. A lot of the criticism on these provisions in my area were in tech companies. And these were fairly sophisticated employees. The California legislature has moved to do what they can under preemption to change that. Can you comment on that at all, specifically to that industry?
Certainly we see a lot of cases in the tech industry. Uber famously has had a long-standing set of conflicts that involve forced arbitration clauses. So it's a critical issue in that industry. California, it's about 2/3 of businesses in California using forced arbitration. So it's having a massive impact there. And there's very little the states can do under the Supreme Court's preemption doctrines. This really needs to be regulated by Congress. Congress is the one that has the ability to act in this area.
Thank you. With that, I will turn to the ranking member, Mr. Allen. Go ahead.
All right, thank you, Mr. Chairman. Mr. King, one of the reasons Congress enacted the National Labor Relations Act was to curtail certain private sector labor and management practices which can harm workers, businesses, and the economy. How did the Supreme Court's Epic Systems ruling in 2018 protect the ability of workers and employers to resolve disputes outside of court? And how would overturning that ruling, as this bill would do, affect workers, businesses, and the economy?
Well, Mr. Allen, the Supreme Court in Epic Systems followed what had been decades of Supreme Court case law. As I mentioned earlier, both so-called conservative and liberal justices agreed in many instances. And what the court did in Epic is to harmonize the Federal Arbitration Act and the National Labor Relations Act. And it's improper to conclude that an employee has no regress. An unfair labor practice charge can be filed on any number of different theories, but also an employee can file, if it has a problem outside of the arbitral system, complaints, charges with the Equal Employment Opportunity Commission, with the National Labor Relations Board, state and federal agencies. So what the court in essence said in Epic, arbitration should be encouraged. It's indeed the intent of the Congress. It can be utilized in a way that's fair. And also in arbitrable systems, the statutory rights, whatever they may be, are preserved, contrary to other suggestions. And there's nothing that undermines the National Labor Relations Act in any way, shape, or form. And finally, the petitioners in the case, those that were asking the court to review the entire matter, laid out, and I have this in my testimony, any number of ways that workers in a non-union environment can work together to pursue individual claims and bring them to the attention of the employer. But let me just, Mr. Allen, finish with one point. This issue of access and filing. Here's what really happens, contrary to the testimony you're hearing, based on practical real-world experience. Cases are settled, as the professor notes in his testimony. Employers have good counsel. They settle matters out. And you have steps in the process, just like in the union process. And during those steps, they're called grievances generally in the union environment, employer and employees reach agreement. That's why you don't have these matters going to any type of arbitration. That's what practically happens here.
Well, in talking about that further, the Constitution provides for equal protection under the law. HR 4841 bans mandatory arbitration agreements that are used to settle disputes between a worker and an employer. Is the bill consistent with how it treats disputes between a union and an employer? And why does the bill treat workers and labor unions unequally?
Well, it's inherently inconsistent. I can't think of a practical or logical reason to support that other than intense lobbying pressure from organized labor. The fact of the matter is, what happens in a labor environment and arbitration is very similar to what happens in a non-union environment. The American arbitration rules are followed in the union environment. They're followed by and large, if not almost exclusively, in the non-union environment. There's not much difference, if any. And this myth that in the employee in a union environment, as I noted in my opening statement, has a lot of control over the process, that's just flat not correct. So there is no rationale that I can think of that would support this differentiation. And the suggestion that somehow these are sophisticated negotiations between a union and an employer to arrive at an arbitration system, that's just not true. The stated arbitration clause in a collective bargaining agreement is generally no different than a non-union environment.
Well, one of our testimonies brought the fact that the appeals process was unfair in arbitration. But I mean, there's an appeals process in the court system, is there not? I mean, I don't quite. In other words, they're both are they both equally unfair, the appeals process, or they both apply to the same process?
Well, first of all, the statement about appeals is a misstatement. There may be certain arbitration cases, certain arbitration clauses that have appeal rights, but generally that's not the case. Where appeals come in is in the court system. And as you know, it takes literally years on the appellate process. I don't see appeals coming in to at least the many arbitrations I've been involved in. They just don't happen.
Well, thank you so much, Mr. King. And with that, Mr. Chairman, I yield back.
Thank you, Mr. Allen. I now recognize Representative Wild for her 5 minutes.
Thank you very much, Mr. Chairman. I first want to address some things that you said, Mr. King. I come at this from a fairly unique perspective on this committee. I was a lawyer for 35 years before I came to Congress. I handled a lot of employment cases. I've represented both plaintiffs, in other words, the employees, and I've represented employers as defendants. And I've also served as an arbitrator. So I was listening to your remarks all of the witnesses' remarks very, very carefully. And I have to tell you, Mr. King, that I differ with your assessment of arbitrators and arbitration generally. First of all, I don't in any way mean to impugn the reputation or qualifications of arbitrators who preside over these cases. But I do have to say that in my experience, which is fairly extensive, arbitrators are very much dependent on repeat business in order to, if they want to maintain arbitration as a full-time practice, as opposed to practicing the other kind of law. And that means that institutional clients, whether it be hospitals or employers or any kind of industry who continually refer cases to them for arbitration, I believe have undue influence. And I don't, again, mean to suggest that they are doing this intentionally, but it is almost impossible. And I speak as somebody who has been an arbitrator, to ignore the fact that a party who has appeared before you on multiple occasions and likely will again, doesn't have some sort of advantage over the lone employee who has this one claim and will never again appear before the arbitrator. So I feel like that needs to be pointed out. In addition, arbitration can be a very, very expensive process. The hourly fees for most of the arbitrators that I used to retain through the American Arbitration Association were somewhere on the order, and this was a few years ago now, of $600 per hour at the low end. So, to suggest that this is an inexpensive process or something that is within the reach of the plaintiffs, I think is unfair. And keep in mind, as has already been pointed out, that the amount of damages recoverable is often, although very significant to the plaintiff, to the litigant, not so significant in the whole big scheme of things for lawyers who are being asked to take on their cases. And by the way, the lawyers who take on the cases for these employees are doing so 9 times out of 10 on a contingent fee basis, meaning that that lawyer is bearing all the expenses while the case is proceeding. And it also means that they are taking on the risk of whether the case will be successful or not. Again, I don't think that we can in any way suggest that an employer and an employee are on a level playing field in the arbitration world. Honestly, I'm not sure that they're on a level playing field in a courthouse either, but that is largely due to jury bias and that kind of thing, which is unique to each jurisdiction and venue. And finally, I think it's really important to note that what we are talking about here today is forced arbitration. There is nothing to stop an employee from agreeing to arbitration when the time arises. If that employee and his or her lawyer makes the determination that arbitration is the way to go, that because of delays at the courthouse, because of jury bias that's known in that venue, an employer and an employee and his or her lawyer may very well make the decision to go forward with arbitration. But what we're talking about here is whether the employee should be forced to go through arbitration. That is really the salient issue. And they do not have equal negotiating power at the time of commencing their employment. So I just felt that those points needed to be made. I'm going to move on to Dr. Colvin, because I have a question for you about wage theft. Dr. Colvin, your testimony notes that almost 65% of businesses that pay less than $13 per hour have forced arbitration clauses. So this would apply without doubt to most fast food workers, most retail workers, and people who literally have no negotiating power over their terms of employment. Am I correct?
That's correct, yes.
According to the National Employment Law Project, in 2019 alone, employees of these businesses lost $9.2 billion to wage theft. Can you comment on how mandatory arbitration contributes to this issue of wage theft?
So one thing we know in that area is that the collective claims, class action claims, are one of the primary ways of addressing those issues, because they often apply to many workers. You imagine in restaurant chains, if you have, say, a minimum wage worker missing a 30-minute break being paid a day, if you take over 6 months, that would only amount to about $435 per worker. That's a pretty small amount, not enough for an individual case. But if you aggregate that over 1,000 workers in a restaurant chain, that's $400,000. That's a case you can bring, and you can move forward with that. So the class action waivers really impact those low wage workers a lot.
So the short version of that is that a single employee who experiences wage theft is likely to be unable to find a competent lawyer to handle his or her claim.
That's exactly right. We just don't see those cases being brought.
Thank you very much, Mr. Chairman. I thank you for your indulgence. I see I am over time and I apologize for that.
That's quite all right. Thank you for your comments. I do want to just mention the California law was directed, as Congresswoman Wild mentioned her comments, at forced arbitration, and it's currently being litigated, but it's been upheld in the Ninth Circuit. Now we'll go to Mr. Wahlberg. Mr. Wahlberg.
Thank you, Mr. Chairman, and thanks to the panel for being with us today. Mr. King, HR 4841 severely limits the use of arbitration agreements and encourages litigation. We all know that litigation is expensive, adversarial, and slow. Can you discuss the shortcomings of litigation in resolving disputes in the workplace as compared to the benefits of arbitration? And additionally, how would a movement toward increased litigation impact low to middle income workers' ability to have their complaints resolved?
Thank you, Mr. Wahlberg. It's nice to see you again, and thank you for the question. Well, let me start by the expense issue. We just heard a comment that it's expensive to go to arbitration. Let me concede that for just a moment, but it's more expensive to go to court. And to somehow suggest that court litigation is less expensive than arbitration is a non-starter. Second, by forcing workers to go to the court system, they're going to be even more hard-pressed to find attorneys. As Professor Sam Estreicher said, and it's noted in my testimony to the House Judiciary Committee, many workers are going to be without any form whatsoever. So just the opposite is going to occur. By having informal pre-dispute systems in place that are fair, and to suggest they're not is also a misnomer. Virtually every arbitral system I know that employers have followed the American arbitration procedures and protocols. Yes, non-disclosure agreements should be examined. Secrecy should be taken out of the process. But the process is fair, Mr. Wahlberg, and it works. And as I said earlier, the reason we don't have more of a filing system here is that workers are arriving at settlements. Now, this is a system that ought to survive. It provides good benefits. But back to your question, House Bill 4841 prohibits altogether any type of pre-dispute arbitration system, period. That makes absolutely no sense.
Let me just add on to the question. In class action lawsuits, do employees often see large financial awards when their claims are successful? And conversely, how do class action lawyers fare?
Well, they go in opposite directions. The lawyers always win, and the employer or consumer, in most cases, in a recent study that I just saw yesterday, even further emphasizes this, do much worse. And the only winners here really are the plaintiff's trial lawyers. It's quite unfortunate. Senator Ernest just introduced a bill last night that would stop that process and prohibit the trial lawyer from receiving any more than the awards that claim it. That's where we ought to have this discussion. It's really interesting. The consumer gets, or the employee gets, the worker gets very little, unfortunately.
It's an old story that we've heard. Mr. King, according to the director of the Administrative Office of the U.S. Courts, as of March 2020, the number of civil cases pending for more than 3 years is nearly 30,000 cases.
Right.
And that statistic came before the worst of the COVID-19 pandemic. What impact would HR 4841 have on the current case backlog, and how would this impact workers?
It would increase that 30,000 figure manyfold, Mr. Wahlberg. The court systems are absolutely overflowing at the moment. I noted in one of the submitted testimonies today that the federal rules of civil procedure have an 8-month target for civil litigation. That's not being met. That's not even close to being met. And in class actions, it takes years, literally years, often just to litigate the procedural issue of whether we have commonality, typicality, et cetera. Class action litigation is a procedural morass. It's one of the absolute worst procedural ways to do business in the courts. So the short answer to your question is dumping hundreds of thousands of worker complaints into our court system is a non-starter. It is just not a practical solution, nor is it a solution, Mr. Wahlberg, to dump those types of cases in a class matter into our arbitral system. That arbitral system can't handle that influx either.
So I guess additional evidence why unions are carved out of this because of the outcomes.
Yes.
Thank you for your testimony. And Mr. Chairman, I will yield back 11 seconds.
You're a generous man, Mr. Wahlberg. Now recognize Mr. Banks.
Thank you, Mr. Chairman. California's AB 5 law, better known as the gig worker law, may be one of the best known failures of a Democrat attempt to regulate labor standards. This law forced companies to classify independent contractors as employees, placing a one-size-fits-all chain around their neck. Mr. King, what effect did this law have on California businesses?
Very negative. And as you know, the so-called worker protections are not there. And the voters in California resoundingly rejected it. So this also is a non-starter. And I see it's woven, at least there's an attempt to weave it in 4841. Absolutely poor policy.
Agreed. Can you tell us more about how did this law affect the shipping industry and help create the supply chain crisis that we're experiencing today?
Well, we literally have, last I saw, hundreds of ships outside of Santa Barbara, outside of Long Beach. The entire industry of moving goods is in a state of flux. And it just brought litigation into those areas. A lot of the companies that move these goods, as you know, are small and medium-sized companies. If they have to divert resources to litigate these matters, they have less resources to pay workers and to improve productivity. It's certainly an impediment in the supply chain.
Mr. King, I appreciate that explanation very much. What's shocking to me is that despite how disruptive AB 5 was, my Democrat colleagues want to expand this law nationally, as you pointed out. The PRO Act, which unfortunately passed the House back in March, contains provisions similar to that of AB 5. Additionally, HR 4841, which is the topic of the discussion today, would prohibit independent contractors from engaging in arbitration if classified as an employee. Can you speak on that, on the disastrous effects of that and that the PRO Act would have for labor standards if they're signed into law?
It's an excellent question. The whole issue of classification, independent contractor status, is quite complex in many scenarios. It'll be dealt with separate hearings, separate proposals, separate discussion. Beyond that, the Federal Arbitration Act, I would at least concede in part, was designed to settle disputes between merchants, between third parties. Why should we take that well-known, well-established procedure where an employer and a third party, merchant or supplier or vendor, cannot enter into dispute resolution? And certainly there, even if you concede there's some uneven bargaining power in how these agreements are established, which is long since passed with procedural safeguards being adopted, but even if you go there, this is an area where you certainly ought to preserve arbitrable pre-dispute procedures. And the final thing I'd note here, our entire jurisprudence system is built on procedures being agreed upon in advance. I can't go into court and ask the court, well, let's change the rules. We'd like to negotiate a different set of rules. The civil rules of procedure are there in place, similar to the American Arbitration Act procedures. So it's a misnomer to say these procedures shouldn't be agreed upon in advance. That's the way the system has worked and should work.
And finally, Mr. King, can you elaborate more with that on the effect that HR 4841 would have on contractors?
Well, it turns upside down the whole definition of independent contractor, worker, and employee. As I read the bill, everybody is an employee. Everybody that even has an agreement to supply goods and services at arm's length has to be brought into an employee status, and therefore no pre-dispute arbitration agreement ever could be entered into. That makes absolutely no good policy sense or common sense. As I said in the outset of my remarks, I'm sure I could sit down with Professor Colvin at an arm's length, negotiate a good pre-dispute arbitration procedure that has procedural safeguards, no secrecy. That's foreclosed. So whether it be independent contractor or anyone else, this bill goes way too far.
Agreed. It seems enormously dangerous. With that, Mr. Chairman, I yield back.
Thank you, Mr. Banks. Just want to make, if anybody listening or has a question, I was referring to a separate bill, Assembly Bill AB 51 that deal directly with arbitration. AB 5 I'm very familiar with as a former chair of the Senate Labor Committee in California. But I just want to clarify that they're two separate bills. Not that Mr. Banks was inferring that. I just want to clarify for the record. Ms. Harshberger, you're next for 5 minutes.
Okay, thank you, Chairman and Ranking Member, and thank you for the witnesses for being here today. Mr. King, I want to read part of your testimony. It says arbitration is usually less expensive and faster than litigation. It can have similar procedural and evidentiary rules. It normally minimizes hostility and is less disruptive of ongoing and future business dealings among the parties. It's more flexible in regard to scheduling of times and places of hearing and discovery devices. And, you know, I've been a business owner for over 30 years. And, you know, if it were me, I would absolutely want to sit down with an employee and have an arbitrator because of the time frame. The hostility factor is huge. Earlier this Congress, as Representative Banks said, House Democrats passed H.R. 842, and that's the Protecting the Right to Organize Act, or the PRO Act. And it is a bill which bans arbitration agreements to settle disputes between workers and employees, and it allows the NLRB to impose large monetary penalties up to $100,000 on employers for unfair labor practices. And that includes violations of the bill's prohibition on arbitration agreements. These huge financial penalties in the PRO Act are consistent. I mean, that would devastate a business, sir, is what I'm trying to say. A $100,000 fine would devastate a business. And I guess, what is your opinion on what would happen if these were consistently applied because there wasn't arbitration?
Oh, excellent question. The PRO Act contains many toxic provisions for business, and you just identified one of the central ones that's apparently still pending in the so-called budget reconciliation discussions.
Mm-hmm.
What, as a practical matter, can happen and will happen is that unfair labor practice charges, without any foundation in many cases, will be filed against medium and small employers particularly. They don't have the financial ability to defend their position. And if the National Labor Relations Board then finds a objectionable conduct, unfair labor practice has occurred, then the business is subject to hundreds of thousands of dollars of potential fines, including representatives on the board, chief human resource officers, owners of the business. Then the Wagner Act, which is the predecessor to the National Labor Relations Act, passed in 1935, never envisioned the National Labor Relations Act to be this type of statute. It's been throughout its history a remedial statute. Both Democrat and Republican Congresses have accepted that. The PRO Act is a substantial, unfortunate overreach, and the civil penalties you just mentioned are totally unneeded.
Well, I don't think a small business could stay in business very long if that happened. And, you know, when you look at the Supreme Court case, Epic Systems, and they encourage arbitration initially, you know, I'm assuming once you do the arbitration and you work everything out, what's the time frame generally that a case is dismissed or penalties taken care of? I mean, is that a reasonable amount of time during arbitration? Is there a standard amount of time?
Yeah, most arbitrations, again, in the workplace, as I noted in my opening comments, are generally involving relatively minor disputes, frankly. Was I paid properly? Did I get my vacation when I should have? Did I get my job bidding rights? Those can and are resolved quickly. In many cases, in less than 180 days from time the arbitrator is selected until her or his award. Correspondingly, in the judicial arena, I just saw stats on this yesterday, you're talking 560 days at a minimum in many cases. And if you are in a class action, you don't even get to the merits of the litigation until sometimes years, because procedural issues of typicality, numerosity, et cetera, are litigated. So much quicker, absolutely no case that I can see out there that's at least supportable would suggest that the court system is more efficient. Just the opposite.
Well, I agree. If you have, in my experience as a business owner, you have 10 different attorneys, you're going to get 10 different answers, but you're going to be billed 10 times too, just FYI. So I appreciate you, and I have a little bit of time left, and I yield back.
Thank you.
Thank you, Congresswoman. You're learning from Mr. Wahlberg. Representative Fitzgerald, your time is here.
Thank you, Mr. Chairman. Mr. King, instead of setting one standard and having everyone play by the same rules, I think where my colleagues across the aisle are, they've singled out the unions for favorable treatment. Yesterday, a very similar bill came forward in Judiciary, of which I'm a member, and I offered an amendment. In that markup in the Judiciary Committee, the amendment was aimed directly at the FAIR Act that removed the exemption for unions in a bill that would otherwise ban the pre-dispute arbitration. Clearly it's a union carve-out. The legislation bans the pre-dispute arbitration for non-union employees while preserving these benefits for the union employees. The discrepancy, it just doesn't make any sense, other than trying to appease the unions, like I said. I mean, but legally, this has to make this entire area of law a little more vulnerable, I would say, and it probably not a wise move when you're talking about this area of statute. Would you agree or disagree, or what do you think? What are your thoughts on that?
Well, good points, Mr. Fitzgerald. It's intellectually insupportable. I don't know how one could say that a union and a corporation, an employer, should be able to negotiate pre-dispute arbitrable procedures and also ban class actions if they so agreed, but yet say, no, that can't occur anywhere else in the world. If it's inherently illegal, unconscionable, unacceptable as a general premise, why isn't that also applicable in the unionized environment? You just can't reconcile those 2 points of view. And to somehow suggest that, as I said earlier, that a union and employer negotiate at arm's length sophisticated, complex arbitral agreements, that's just not reality. What those agreements look like are the same as we see in the non-union field. So there ought to be a level playing field here. And as noted by the previous questions, this whole attempt to fine employers, to force employers into dealing against the will often of their employees in a union environment is just a pressure play to chill the rights of employers and to cause them to have all kinds of litigation and regulatory problems. It's not a playing field that's fair.
Very good. Thank you. Just one other quick question. So the other thing about HR 4841 is it applies to employees of the employer as well as independent contractors. And in my estimation, I think that this will have a direct effect on, for the most part, entrepreneurs or people that are trying to do a startup. And I'm wondering if you could make a brief comment on that part as well.
Oh, absolutely. It's an end around of an intelligent, thoughtful discussion about whether an individual is an employee or an independent contractor, a merchant or a third party. Those are all entirely separate issues. If you foreclose merchants, third parties, and others, employers, the user employer, from negotiating pre-dispute agreements, and you prohibit them from carving out class actions, you're forcing everybody into the courts and primarily into class action litigation. That makes no policy sense. It's inefficient. It's the wrong way to go about that discussion.
Very good. Thank you, Mr. Chair, and I would yield that.
Thank you, Mr. Fitzgerald. We'll now recognize Congresswoman Miller for 5 minutes.
Thank you, Chairman DeSanter, Ranking Member Allen, and all our witnesses. While the committee Democrats and those that object to arbitration agreements in general argue that their intention is to get better outcomes for claimants through litigation, that is not the answer. Mr. King, in your testimony, you mentioned how proponents of banning arbitration in this hearing are citing faulty studies. You cite studies that show only 13% of class action lawsuits result in payout, and the average award is about $32, while plaintiffs' attorneys got about $1 million. Would you please elaborate on how the studies you cite are correct and how others that are cited are misleading?
Thank you, Congressman Mills. First of all, as I mentioned, the recent study by the Plaintiff Trialers Association counted all settlements as losses for workers. That's inherently misleading. It's really a disservice to this discussion. Second, in some of the statistics we've seen, and I certainly respect Cornell University, it's my alma mater and my law school, but in all due respect to the IRL studies, they're comparing jury awards to standard, what I would call run-of-the-mill arbitral workplace settlements. You just can't do that. That's, as I said, apples and zebras. And the disparity, Congressman Mills, between what the claimant is getting in court compared to what the claimant is getting in arbitration, the figures we are citing is as close as possible to a real-world apples-to-apples study. And study after study, indeed the updated study that I just saw yesterday, refutes entirely this suggestion that plaintiffs and workers are doing better in the court system. And where the real reward in that court award is going, as inherent in your question, is to the trial lawyer, not to the consumer, not to the worker.
Thank you. That was interesting, especially in light of the fact I'm reading a book called How to Lie with Statistics. Mr. King, your written statement quotes Supreme Court Justice Breyer on the advantages of arbitration. Is Justice Breyer's statement of support for the arbitration process unusual? Have other judges across the ideological spectrum made similar statements?
Yeah, absolutely. He's not alone. I would hardly label Justice Breyer an outlier, but Justices White, Justice Kennedy, Justice Kagan, and many other justices of varying philosophies have clearly articulated in their written decisions that arbitration is the preferable way to proceed. It is the congressional intent behind the Federal Arbitration Act. It is the law of the land. But even if you rejected those very thoughtful opinions by very intelligent people, and even if you reject decades of court case law, as Mr. Allen said at the outset, our court system and arbitration system is not equipped to handle hundreds of thousands of disputes that would be put into that system. That's not workable. So let's do a reality check here. If you really want to get to the heart of this issue, let's encourage employers, workers, even unions to have alternative dispute resolution procedures, settle these matters in the workplace informally, thoughtfully, and expeditiously.
Thank you. That's good information to know. And finally, Mr. King, as I speak with my constituents, the most frequent thing that I hear is that they're having a hard time retaining and finding new employees. If we were to ban arbitration agreements, how would this harm employment?
Well, you know, it's interesting. We hear this disparity of bargaining argument that workers are being forced to accept these agreements. Well, first of all, more and more companies are making them optional, and they're not being forced, as suggested in testimony, upon workers. Second, workers in this economy particularly will go somewhere else if they find the system to be inherently unfair. And third, given our platform economy, if word is out on the street that employer X is unfairly treating its workers in so-called forced arbitrations, they'll go somewhere else to work. So this worker shortage is having a very interesting impact upon this entire discussion. But inherent in our whole system, I mean, workers don't have an opportunity to renegotiate the civil rules of procedure in the courts. They don't have the ability to renegotiate arbitration rules and regulations by the American Arbitration Association. So this whole discussion is off kilter in that regard.
Thank you. Thank you again to all of our witnesses, and I yield back.
Thank you, Congresswoman Miller. I now recognize Congressman Mervan for 5 minutes.
Congressman, if I could, if I could be recognized for 5 minutes in about 2 minutes, I'd greatly appreciate it.
I'm sure the ranking member of the full committee would love to go now, if that's appropriate. Ms. Fox, if you're ready to go, your 5 minutes are here. I always want to show you the deference you so richly deserve, ranking member.
Thank you so much, Mr. Chairman. And I always love seeing you on the screen. Like to see you in person better, but I love seeing you on the screen. Thank you so much. Mr. King, for over 80 years, Congress has struck a careful balance in federal labor law with respect to the interest of workers, employers, and labor organizations. However, H.R. 4841 encourages adversarial class action lawsuits between workers and employers while preserving labor union access to arbitration. Is H.R. 4841 consistent with the balanced approach of the National Labor Relations Act?
Dr. Fox, very nice to see you again, albeit virtually.
Thank you.
There is no balance, as we just discussed. I don't know how you intellectually or practically defend a carve out for union agreements in this area. If you accept the premise of 4841 that pre-dispute arbitration is completely bad and should never be utilized, then the same ought to be applicable in the union environment. But of course, that's a misnomer and a false premise to start out with. And to say that you can never have a class action abridgment or prohibition in the non-union sector, but yet you could have it in the union sector, that's, again, inherently inconsistent and not intellectually supportable.
Thank you very much. Mr. King, in the EPIC Systems decision in 2018, Supreme Court found that the NLRA and the Federal Arbitration Act are not in conflict, and that workers' ability to organize unions and collectively bargain does not guarantee the ability to litigate as a collective entity. In your view, was this finding correct, and what implications does it have for the NLRA?
Well, I think it's an absolutely correct decision. It codified decades of Supreme Court case law that, as we just established, had various judicial philosophies in those previous decisions. The Wagner Act, the predecessor of the National Labor Relations Act, was passed in 1935. 1935. The Federal Arbitration Act was 1925. So the authors of the NLRA, the Wagner Act in 35, they knew of the Federal Arbitration Act. If they had wished to include class action protection in the National Labor Relations Act, they certainly could have done so. They did not do so. The National Labor Relations Act, as Supreme Court said in EPIC, doesn't have any provision that guarantees class action litigation.
Thank you. You mentioned in your testimony, H.R. 4841 creates new unfair labor practice charges against employers, and that this is even more troubling in view of the Democrats' impending budget reconciliation bill. When this legislative monstrosity was considered by the Education and Labor Committee in September, the Democrats included an appalling provision, which for the first time, even under the NLRA, creates massive civil monetary penalties against employers and corporate officers. Can you elaborate quickly, please, on why this combination is so unprecedented and dangerous.
The National Relations Act in its many decades of history never has included fines against employers. This is an attempt to chill employers to exercise their rights. It's also an attempt to chill employers to respond to unfounded unfair labor practice charges. Small and medium-sized businesses are going to be put in a very difficult position. It is inherently not fair. It's certainly not needed. It's an overreach.
Thank you. Mr. King, when Congress considers a piece of legislation, we should be absolutely clear about how the legislation would affect the American people. Your testimony states that arbitration is an effective and proven method for resolving workplace disputes. Would you elaborate on the advantages of arbitration for workers any more than you might need to based on your previous testimony?
It's quicker. It's more informal, as we discussed earlier. It forces the employer and the employee to sit down with one another. And you know what is it? Dr. Fox, is a practical matter what really happens here. Let's put aside all this philosophical approach. It forces the parties to come to an agreement. And in my experience over 50 years, there's a very high settlement rate, not only in the arbitral system, but also in the courts, but particularly informal arbitration procedures, pre-dispute arbitrations lead to settlements. And that's what we all ought to strive for here.
Thank you. And Mr. Chairman, thank you again for letting me help out Mr. Mervan as he was walking over. I see the technique he used. I thought I was going to be in that position too, of running over here. He and I were just on the floor. So I ran like crazy to get over here. I move a lot faster than he does, by the way. So anyway, I'm glad we were able. I like him and I like you. Thank you, Mr. Chairman. I yield back.
Thank you, Congresswoman Fox, the most charming member of the House of Representatives. Mr. King, I would agree with you on this. Congresswoman Fox is always best in person. Congressman Mervan, 5 minutes is yours.
Thank you, Chairman. And Congresswoman Fox, I played in the football game yesterday. I can barely blink without being in pain. So that's why you beat me. But respectfully, I thank you everyone for the opportunity. Professor Colvin, can you explain the difference between individual forced arbitration and the forms of arbitration that many unions require through collective bargaining? Why is arbitration more appropriate when it is a part of collective bargaining agreements?
It's a great question. There's a fundamental difference to how arbitration operates in the collective bargaining context, what we call labor arbitration. It's a system that's been around since the 30s, 40s, that has been very successful for ensuring collective agreements are enforced and as an alternative to strikes in the workplace. What's really different there is that the system operates with two sophisticated parties, two repeat players, one on each side. What that means is that the arbitrators are responsible to both parties. The cadre of labor arbitrators who decide these cases are widely respected by both sides. That's why the system works. That's what's different on the forced arbitration side, where you have one side, large sophisticated corporations, and on the other side, individual employees who are not repeat players. They don't have the same engagement, same ability to hold the system to account. And what we see is much more variation across arbitrators in making decisions on the forced arbitration aside. It's not consistent the way it is in labor arbitration. The other major difference, and here I have to disagree with what Mr. King's testimony suggested, is that the types of cases are really different. Labor arbitration is dealing with regular workplace, day-to-day disputes about scheduling, about job assignments, those kind of things. Forced arbitration, we did a study where we spent time reading through a whole year's worth of all the forced arbitration cases decided under the administration of the American Arbitration Association. And what we found is half of them are discrimination cases, another 10% are wage and hour cases, and the rest are other statutes and common law claims. They're not typical workplace day-to-day problems. They're legal issues. They're much like the kinds of cases that you see in the court system. So it's really different from what goes on in labor arbitration. Labor arbitration works well with two repeat player parties, a well-established group of labor arbitrators who are trusted by both sides. They're really different systems.
Professor Colvin, in your testimony, you cite research by Cynthia Eastlund that suggests the cases are brought in forced arbitration at a rate of only 1% to 2% when compared with cases brought in court. Given the rates of forced arbitration you describe, is it fair to say that this means for a large percentage of the workforce, our employment laws are going unenforced?
That's exactly right. In theory, you could create a new dispute resolution system that was accessible to all workers and have a lot of claims. Professor Estreicher, who was mentioned earlier, made this argument about 20 years ago. Maybe we could have an arbitration system that looks like that. However, when we do the empirical research, we don't find that forced arbitration produces that system. There's hardly any cases that are small. 3/4 of the claims filed are over $60,000 claims. These are similar to the kind of claims that are filed in court. They're not small claims. We don't see the accessibility. And the reality is, if you don't have the accessibility, then for most American workers, you're not seeing their employment rights being enforced.
Can you lay out the factors that make claims so much less likely to be brought under forced arbitration than they would be under if the worker had access to the courts?
So one thing I think that has to be recognized is something that you heard in Ms. Perez's testimony, that there's procedural complexity in arbitration that gets unrecognized. She, as an individual worker without legal representation, it's not really possible to easily navigate this system. It's more complex and has become more complex over time. It's also the case that what you see successful in arbitration systems is sort of larger, higher income, sophisticated parties with substantial resources. Those are the ones that succeed. By contrast, our employment laws are really there to try to protect the typical American worker without large-scale resources or sophisticated legal representation. You've got to protect those workers, and that's the challenge here.
I thank you. With that, I yield back.
Thank you, Congressman. I don't see any other members, so want to thank all the witnesses. I didn't imagine being so dominated by Cornell. I felt like all of a sudden singing "Hail, Hail, Cornell." So thank you for High Above Coyote's Waters. I've had some friends who attended. But I do want to thank all the witnesses. You were terrific. Pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing. So by close of business on November 18th, preferably in Microsoft Word format. Only a member of the subcommittee or an invited witness may submit materials for inclusion in the hearing record, and the materials must address the subject matter of today's hearing. Please submit materials to the committee clerk electronically by emailing submissions to the edandlabor.hearings@mail.house.gov. Again, I want to thank the witnesses. I did want to mention that unfortunately, some members, particularly on our side, weren't able to attend because they were attending a memorial services to former Congressman Kildee from Michigan, the uncle of our colleague, Representative Kildee, who served for many years on this committee. So just want to let people know that many of us wished we could have been there. And again, one last time, thank you all, even the people who aren't affiliated with Cornell, for participating as witnesses today. If we have other additional questions for you, we may ask that you please respond to those questions in writing. The hearing record will be held open for 14 days in order to receive those responses. I want to remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The question submitted must address the subject matter of the hearing. I now want to recognize our distinguished ranking member for closing statement.
Thank you, Mr. Chairman, and my condolences to Dan and the entire Kildee family. As I heard also about the memorial service this morning at our prayer breakfast. As we heard today, HR 4841 will only add to the challenges job creators and American workers are already facing in this struggling economy. We've had great testimony by our witnesses, and I thank all of our witnesses for participating today in this important hearing. Based on my experience as a business owner, I know that banning the use of arbitration will unfairly penalize individual employees and employers by delaying resolutions to their workplace disputes. Arbitration is a proven method for solving employment issues and is often a lot quicker and less expensive than court battles, resulting in swifter justice for proven incidents of wrongdoing. HR 4841 is contradictory in its effort to ban pre-dispute arbitration and class action waivers between employees and employers, because the bill still allows employers and unions to continue negotiating agreements through the same process. This blatantly one-sided approach allows unions a huge advantage, which is in conflict with principles of equal treatment. HR 4841 also unfairly penalizes independent contractors and fails to recognize that they are entrepreneurs who set their own hours and earnings. By putting independent contractors in the same category as salaried or hourly employees, HR 4841 will decrease opportunities for these American workers at the very same time that flexible employment options are needed the most. Forced lockdowns, a supply chain crisis, rising inflation, and worker shortages are already wrecking our economy. This legislation, if signed into law, could be the nail in the coffin for many struggling job creators. As I stated in my opening statement, the only thing HR 4841 is good for is enriching trial lawyers. The legislation will result in ongoing class action lawsuits, leaving many workers' claims unresolved due to the costly and time-consuming nature of litigation. I'd like to again thank our witnesses for participating today. And with that, Mr. Chairman, I yield back.
Thank you, Mr. Allen. I really appreciate that. Again, I want to thank all my colleagues. Thank you for adhering to the 5-minute rule and the witnesses. And I, as a former employer and for many, many years, meeting a payroll, and as Mr. Allen and others have said, what I hope for is a structure that's balanced. And I think we all agree on that. Our perspectives may be different. And one of those occasions, I agree with a Hoover Institute person, Francis Fukuyama, when it's best if we avoid this in the employer-employee relationship, if both sides treat each other with respect and not get into these situations. As he enumerated in his book, Trust, that's probably the most efficient way. But knowing human nature, that's not always possible, and that's why I believe strongly in this bill, but value the perspectives and hope to continue the conversation. Now, I'd like to recognize myself for a closing statement. Today, we highlighted the importance of passing legislative solutions to end forced arbitration and ensure that workers have a fair shot at securing justice. Access to the American legal system is an essential pillar to our democracy. Unfortunately, for decades, employees have been coerced, oftentimes, into signing arbitration clauses that have closed the doors to the courtroom. As a result, some employers duck litigation and evade accountability at the expense of workers' rights. Congress must pass, in my view, the Restoring Justice for Workers Act to ensure that workers can band together to hold employers accountable for wage theft, harassment, discrimination, and other violations of essential workplace positions. I look forward to working with my colleagues on both sides of the aisle to better protect workers. Thank you again to our witnesses. If there's no further business without objection, the subcommittee stands adjourned. Thanks again.
Thank you, Mr.